HMRC have issued a brief to confirm 3 shifts in policy on transfers of going concern. This follows an extended review of the First Tier Tribunal's decision in Robinson Family Limited, which was decided by the FTT in 2012. That case featured a business that held a long lease of premises for which the business had found a subtenant. HMRC accepted that leasehold interests can be transferred as a business as a going concern if there is a sitting tenant and the owner's interest is transferred. There was a side issue about the fact that the subtenant hadn't yet taken up occupation of the property, but the main argument was not about that. Rather, it was because the person to whom the business was transferred was not sold the owner's interest, but rather granted a very slightly shorter lease of the premises, as I recall, 3 days less than the 125 years that the grantor owned. The subtenant then signed a sublease with the grantee and started to pay rent. HMRC argued that none of that could constitute a TOGC because the thing owned by the owner had not been transferred. A new asset had been created, a subordinate lease granted to the new landlord, and that was fundamentally different from transferring an existing asset. The tribunal decided that the substance of the transaction had to be considered, not just the legal form. The recipient had been put in a position to carry on a business in succession to the previous owner. The new lease, together with the agreement of the subtenant to take up occupation, was all the grantee needed to be a landlord. Although it was legally different, the new lease was economically the same as the head lease. The owner would get the property back for 3 days in 125 years' time. HMRC subsequently accepted that decision as appropriate for the type of situation in the case itself, that is, where a rental business was transferred by the owner granting a lease to a new landlord, rather than by transferring its own interest completely. Revenue and Customs Brief 30 of 2012 set out their view at that time, which included a slightly contentious point that the value of what the owner had to retain should be no more than 1% of the total value of the property before the transfer. That would clearly be satisfied by the circumstances of Robinson Family, but it didn't seem to be required by the tribunal's decision in the case. After all, if you were granted a 20-year lease with the benefit of the subtenant, you would be carrying on a business for the foreseeable future for VAT purposes, and I don't think the fact that the grantor had retained a more significantly valuable interest would make much difference to that. However, no one has yet decided to argue that point. A new Revenue and Customs Brief has now been issued to explain that the principle will be applied both prospectively and, if people make a claim retrospectively, more widely than was set out in the earlier statement. First, they now accept that the surrender of a lease can in principle be a transfer of going concern for VAT purposes. Suppose that a head landlord has granted a lease to a lessee, or the current lessee has taken an assignment of an existing lease from a previous lessee, so the lessee currently owns a leasehold interest in the property and has sublet it to a subtenant. There's a rental business that can in principle be transferred as a going concern. Instead of assigning the lease with the sitting tenant to someone outside this diagram, the lessee surrenders the lease to the landlord, who then becomes the direct landlord of the subtenant. HMRC have historically taken the view that a surrender can't be a TOGC because the asset transferred, the lease, will usually cease to exist, becoming merged with the landlord's superior interest. This view has changed because of the First Tier Tribunal's view that it's necessary to look at the substance of the transaction rather than the precise legal form. In substance, the payment of rent by the subtenant is the business, and that has been transferred from the lessee to the head landlord, so the transfer of going concern provisions can apply. The Robinson Family principle doesn't only apply to rental businesses. HMRC also accept that the principle would be relevant where someone uses a property to run a retail business and then grants a lease to someone else who carries on the same retail business in it. The nature of the transferor's activity has changed. They used to be a retailer and now they're a landlord. But that isn't particularly relevant to the TOGC provisions. You think about what the transferee has received, not what the transferor has retained. And although the transferee hasn't received everything that the transferor owned previously, they have received what they need to be put in a position to run the business, that is, the fixtures and fittings of the shop and the stock, and the use of the shop premises. You don't need to own the shop after all. As long as you have a lease or a licence to occupy, you can carry on your retail trade. That was confirmed by the Court of Justice in Finansamt Ludenscheid v Crystal Shriver, which came out a bit before the Robinson Family decision, but which shows that the UK FTT chairman was very much in line with the thinking of the Court of Justice. HMRC also comment on the requirement given in Revenue and Customs Brief 30 of 2012 that the value of the interest retained is no more than 1% of the value of the property immediately before the transfer. This should be based on the relevant part of the building, rather than the value of the whole building, if only part of the building is transferred. That's explained with examples in the brief. Another unrelated area in which HMRC now accept that the TOGC principle should apply is in respect of a person acquiring a completed residential or charitable development. HMRC will now accept that such a transferee inherits person constructing status for the purposes of Schedule 8 Group 5 and is therefore capable of making a zero-rated first grant of a major interest. Traditionally, HMRC have not accepted that person constructing status could be transferred to a person acquiring a completed residential building as one of the assets in a TOGC. They now accept that recent cases in this area have highlighted that such transactions could lead to inequality of VAT treatment that's contrary to the purpose of the zero rate and possibly might be in breach of the EU principle of fiscal neutrality. The guidance in their internal manuals will be amended in due course. There are some transitional aspects to the change of policy. It applies immediately. However, to allow for businesses having to make changes to systems or to contracts, HMRC will allow taxpayers to delay implementation for 4 weeks from the date of the brief, which was the 9th of July. Businesses can claim the benefit of the new policy retrospectively, subject to the 4-year cap. That is a more difficult area because the further conditions for a TOGC, such as the notification that an option to tax would not be disapplied, will not have been met. However, provided the parties can show that the notification could have been given at the time, HMRC will accept that the transfer qualified as a TOGC. This may allow a reduction in output tax charged on a taxable transfer or a restriction of input tax on an exempt transfer. Retrospective claims may also be made for a reduction in stamp duty land tax, where the gross consideration for a supply would have been lower under the TOGC treatment.